Hello, this is Alexander Cross, Criminal Defense here in the San Francisco Bay Area. If you'd like to learn more about criminal defense, don't forget to subscribe to our channel, Law Offices of Cross & Associates, and feel free to ask questions in the comment section below so that we may respond in the future with more videos. So, we received an interesting inquiry here on our YouTube channel. This has to do with somebody who was got in trouble for an attempted robbery and a fight. Let's see here. My adult daughter, together with friends, tried to rob a liquor store, but ended getting into a fight with some people. The police arrived, and they tried to flee, but they were arrested. Well, okay, so she's an adult. So obviously, she's going to be brought to adult criminal court, and she did this together with friends, which means that if she had a plan to commit a crime along with friends, that would be a felony, which would be conspiracy under Penal Code Section 182, which carries up to 3 years in state prison. Now it says right here they tried to rob a liquor store, so it's an attempted robbery. Now robbery usually under Penal Code Section 212.5 is a felony that carries up to 6 years state prison, plus it's a strike. Attempted robbery under Penal Code Section 664/212.5 that will carry half the sentence, which would be 3 years state prison. Now, I have to be clear, robbery is using force or fear to obtain personal property of another with the intent to permanently deprive the owner or possessor of that property. I want to make sure, because sometimes people will say, I got robbed, but it's not literally a robbery. It might be a larceny or some other type of theft or grand theft or something like that. Robbery is very specific. It's using force or fear to take personal property of another. It says right here that also they got into a fight with some people. Well, did anybody get hurt? Were punches thrown? Was it just a verbal argument? It makes a huge difference, because if punches were thrown and whatnot, well, there might be potential charge for battery under Penal Code Section 242, which carries up to 6 months in county jail, and that's assuming nobody suffered any kind of great bodily injury. If somebody suffered a great bodily injury, it could be a felony battery under Penal Code Section 243(d), or there could be a great bodily injury enhancement attached. And then, of course, fleeing from the police, well, it depends. Did your friends and your daughter flee before the police got there? Or did they run from the police, and were the police having to do a little chase? The reason is because if the police had to physically chase you, well, then that's a form of obstruction of justice. That's a misdemeanor here in the state of California under Penal Code Section 148(a)(1), which carries up to 1 year in the county jail. So there's a combination of charges that your daughter could be hit with, and it's extremely important for her to contact a criminal defense attorney as soon as possible in order to avoid things getting worse. Regardless, if you'd like to learn more about criminal defense here in the San Francisco Bay Area, don't forget to subscribe to our channel, Law Offices of Cross & Associates, and feel free to ask questions in the comments section below so that we may respond in the future with more videos for you. But if you've been accused of a crime here in the San Francisco Bay Area and need representation in court, call us now for a free consultation at 1-800-862-7677. Once again, 1-800-862-7677. On our next video, we're going to be discussing the case of somebody who was driving at a high rate of speed under the influence of marijuana. Criminal lawyer, criminal lawyers, DUI lawyer, DUI lawyers, criminal attorney, criminal attorneys, DUI attorney, DUI attorneys.